Understanding Section 48, the basics of this migration rule. Section 48 is a specific part of Australian law. It is found in the Migration Act of 1958. This rule has been in place for many years. Its main purpose is to control visa applications. This control applies to people already in Australia. They might have had a visa refused previously, or they might have had a visa cancelled. Section 48 aims to ensure orderly migration processes. It is a very important rule for many visa applicants. This provision exists for several important reasons. The Australian government wants to maintain the integrity of its visa system. Section 48 helps to achieve this important goal. It discourages people from staying in Australia unlawfully. It also discourages repeated, unmeritorious visa applications. The rule ensures that visa processes are followed correctly. It supports fairness for all applicants. Understanding this helps to see why Section 48 is strict. It is a key part of Australia's immigration framework. So who is directly affected by Section 48? It primarily impacts individuals within Australia. These individuals do not hold a substantive visa. A substantive visa is any visa except a bridging visa, a criminal justice visa, or an enforcement visa. They must have had a visa application refused since their last entry, or they might have had a visa cancelled. This situation puts them under the Section 48 bar. This means they face limits on applying for new visas. They cannot easily apply while still in Australia. Navigating Australian immigration law can be complex. Section 48 adds another layer of this complexity. Many people find this rule confusing. It can create significant stress for applicants. They may feel unsure about their options. Knowing the basics of Section 48 is the first step. It helps in understanding potential pathways forward. This essay will explain more about these restrictions. It will also discuss important exceptions to the rule. This information is for general guidance only. The core restriction of Section 48 is quite clear. It generally stops you from applying for most other visas. This applies if you are in Australia. It also applies if you have had a visa refused or cancelled. This refusal or cancellation must have happened after you last entered Australia. You must also not hold a substantive visa at the time of application. This means your options become very limited. You cannot simply lodge another application for many common visas. This restriction is often called the Section 48 bar. Let us consider a simple example. Imagine Sarah came to Australia on a visitor visa. While here, she applied for a student visa. Unfortunately, her student visa application was refused. Sarah now does not hold a substantive visa. She only has a bridging visa linked to the refused student visa. Because her student visa was refused while she was in Australia, Section 48 now applies to her. She cannot apply for most other visas like a skilled visa while she remains in Australia. This situation can be very challenging for people like Sarah. What does this mean practically for affected individuals? Usually, if Section 48 applies, you must leave Australia. You need to depart the country to lodge a new valid visa application. This is the general rule for most visa types. This departure requirement can cause significant disruption. It can affect your work, your studies, or your family life. Planning for departure can also be costly. It adds another hurdle for those wanting to stay in Australia. It forces a break in their time here. The emotional and practical difficulties can be immense. Being told you cannot apply for a visa while in Australia is stressful. It creates uncertainty about your future. Families can be separated if one member is affected by Section 48. Arranging travel and finding a new visa pathway from overseas takes time. It also requires careful planning and resources. The impact of Section 48 is therefore very significant. It is not just a technical rule, it has real-life consequences for many individuals and their loved ones. While Section 48 is restrictive, there is some hope. The Migration Act does allow for certain exemptions. This means that even if Section 48 applies to you, you might still be able to apply for a specific, limited list of visas while remaining in Australia. These exemptions are very important. They provide a crucial pathway for some individuals. It is vital to know which visas fall under these exemptions. Not all visa types are exempt from this strict rule, so careful attention is needed. Many common visa types are not generally exempt from Section 48. For example, you usually cannot apply for most general skilled migration visas. You also cannot typically apply for many types of student visas or visitor visas if barred by Section 48. However, the regulations list a few specific visa subclasses that are exempt. These exemptions are prescribed in migration law. The list of exempt visas can change over time, therefore it is always best to check the current legislation. This ensures you have the most up-to-date information. A very significant exemption to Section 48 is the Partner Visa. Specifically, this includes the Onshore Partner Temporary Visa, Subclass 820. It also includes the Partner Permanent Visa, Subclass 801. These visas are for people who are in a genuine relationship with an Australian citizen, an Australian permanent resident, or an eligible New Zealand citizen. If you are in Australia, affected by Section 48, but meet the criteria for a partner visa, you may still be able to apply. This is a major lifeline for many couples. Besides the partner visa, there might be other limited exemptions. For instance, applications for protection visas, subclass 866, are generally exempt from Section 48. Certain bridging visas can also be applied for. Sometimes specific legislative instruments might create temporary exemptions for other visa subclasses. However, the partner visa, subclasses 820-801, remains one of the most commonly used and important exemptions. It allows eligible individuals to regularize their status without needing to depart Australia based on their relationship. Understanding these specific exemptions is key. The partner visa exemption is incredibly important for applicants. It offers a lifeline to those affected by Section 48. If you have had a previous visa refusal or cancellation, Section 48 can seem like a dead end. However, if you're in a genuine relationship with an Australian partner, this exemption changes everything. It means you might not have to leave Australia. You can apply to stay with your loved one. This helps to keep families together. This is a very compassionate aspect of the law. This exemption has profound implications for applicants. It provides a clear pathway to remain in Australia. It allows them to continue building their life with their partner. Without this exemption, many individuals would face separation from their Australian partners and families. They would have to leave the country and apply from overseas. This process can be lengthy and emotionally draining. The partner visa exemption under Section 48 therefore offers stability. It also offers hope during a very uncertain time. It acknowledges the importance of genuine relationships. It is crucial to remember that immigration laws are dynamic. They can change, and they do change frequently. The information provided here as of June 2025 is for general understanding. Exemptions and visa criteria can be altered by new legislation or policy updates. What is an exemption today might be modified in the future. Therefore, relying on outdated information can be risky. Always ensure you are referring to the current regulations. Staying informed is absolutely essential for any visa applicant. This is especially true for complex cases. Given these complexities, seeking professional advice is highly recommended. Immigration specialists, such as the team at BMS Global, can provide personalized guidance. They understand the nuances of Section 48. They also know the current exemptions, including the partner visa. They can assess your individual circumstances accurately. They can help you understand your options and prepare a strong application if you are eligible. Navigating immigration law alone can be daunting. Expert advice can make a significant difference to your outcome. It ensures you make informed decisions.